Today, I would like to review some of the important issues that require attention in connection with acquisitions of energy projects, whether they're power plants, midstream assets, or other energy assets, both in connection with undertaking due diligence as well as negotiating the acquisition agreement. The buyer and the buyer's counsel need to make sure to consider the following. First, material project agreements. In many transactions involving an energy project acquisition, the primary economic value is associated with the offtake agreement or power purchase agreement. Often ground leases, interconnection agreements, or fuel supply agreements also contain provisions that have important bearing on the overall value of the project. These agreements require significant review to identify economic or legal pitfalls to the buyer. Second, environmental and related permitting. Both the buyer's lawyers and its consultants need to carefully review any Phase 1 reports and other environmental assessments to identify any contamination, hazardous materials, or other issues that may create ongoing liability to the project owner. Frequently, an issue that requires negotiation between buyer and seller is determining which party might bear the cost of any obvious and necessary remediation or cleanup. Third, capital expenditures. Most existing operating energy facilities have capital expenditure plans and budgets that call for various work to be done to the facility each year to ensure that it remains in good working order, complies with permits and environmental laws, and is capable of generating the energy and capacity necessary to satisfy its obligations under any offtake agreements. As part of diligence, the buyer needs to determine whether an appropriate capital expenditure plan is in place and whether the seller has complied with the plan. Finally, in addition to being part of the buyer's due diligence, all of foregoing issues and many others will be incorporated into the purchase and sale agreement and require representation and warranties to be made by the seller as to the truth and accuracy of these items. Accordingly, among the most important issues is making sure that the seller has agreed to adequate post-closing indemnities for these various items and that the time period during which these indemnities are in place is sufficient for the buyer and new owner to be able to determine whether in fact the seller has complied with these obligations. Equally important as to the time period for the post-closing indemnity is that post-closing, either the seller or a seller guarantor must have the financial strength to be able to back the post-closing guarantee. In conclusion, when acquiring an energy project, there are numerous business and legal issues that are critical to the buyer, and these issues may vary from project to project. However, the issues that we have discussed today tend to be important issues in virtually all energy project acquisitions and require careful diligence, analysis, and negotiation.